Thank you, Dave and everybody. So as most of you know, I am Georgina. I am an associate director at Bridge Employment Law. So we are a niche employment law firm. We're a team of 8, and I have worked with Lee and at Bridge for 8 years now. We are, as you can see from the symbol on the slide, Legal 500, which means we've got an accreditation to say that we're in the top 500 legal firms in our sector in the country. I've noticed this morning that the symbol says 2024. We do still hold this accreditation. We did have it in 2025, and our application is in for 2026. We've no reasons to believe that we won't be granted it again. So that was a really nice accreditation to get for the firm and for the team. We worked quite hard to get it. We are, as I said, a team of 8. So there's 5 qualified solicitors on the team, of which I'm one. We have 2 paralegals. So we've just got 2 lovely university graduates joined us in the summer, which has given a real lovely injection of youth and enthusiasm to the team. And we've finally got people to do our the photocopying and all that sort of work. And we have an amazing practice manager who keeps us completely on track and who we couldn't live without. We do the full end-to-end employment law and HR support. Just to clarify, we do legal work. We have a very trusted core team of HR, independent HR consultants who we work closely with, so we can offer our clients the employment law support, but then if they need the more HR support, we can get in touch with one of our independent HR consultant partners, and we can helicopter them in. And I'm happy to say that the lovely Chloe from this group is in our group of HR consultants through having met her on the LMP. The work she's done for some of my clients is amazing, so I heartily recommend Chloe, and we're hoping to work together more closely in the future. So that's what a bit about Bridge. Just to give a slight run through of what we do. So the majority of work that we do at Bridge is for companies. So we predominantly act for businesses. And that's things, again, I'll rattle through with just bullet points of the sort of day-to-day stuff we're generally doing. Drafting contracts and policies, be it for employees, self-employed contractors, workers, director service agreements, all that sort of thing. Policies and handbooks. We assess employment status, which I'm going to touch on a little bit later in my talk. We deal with quite complex areas of law, such as TUPE, post-termination restrictions, which some of you might be familiar with, confidential information breaches as well. And again, I'm going to talk in a bit more detail about those things a bit later on. We do a lot of tribunal defence work, as you'd expect. So at any given point in time, one of the team or a number of the team are in and out of the tribunals. That's defending claims brought by employees against our clients. So we do the full remit from taking initial instructions, submitting the defences, all the case management work, including representation in the tribunal hearings themselves. We've got David on the team, who's an incredible advocate. And he does all our employment advocacy in the tribunal. So it's a real string to our bow. We're very lucky to have David. He's awesome in the tribunal. We did a mock tribunal not so long ago for some of our HR consultants, and I was unlucky enough to act to the witness opposite David. So I was subject to David's cross-examination, and it was literally the most horrendous thing I've ever been through in my life. So I can firsthand say how good he is. And the sorts of claims that we might be defending at any given time are wrongful dismissal, unfair dismissal, Equality Act discrimination, so your disability, sex, race, all those sorts of things, whistleblowing, pay claims and TUPE claims. We also give strategic advice to all of our clients on exiting employees. So if they've got an employee who's a bit difficult, they're wanting that employee out, we can advise on the best way of exiting that employee with minimal risk, with a specific focus on director level exits, which can be really complex, particularly when they've got shareholder involvement, stuff like that. Again, following from that, we advise on settlement. So we've exited somebody, we want to do it in the safest way. That might be getting them out with a settlement agreement. We do all that sort of thing. And we do strategic day-to-day employment law support as well. Just to touch quickly on the bottom bullet point is the business immigration. That's the part of the team that I head up. So I help clients to get sponsor licenses to enable them to recruit from outside the UK and Ireland. So do that too. We don't exclusively work for companies. It is our preferred work, and it is the majority of what we do, but we do act for individuals as well. So again, that might be bringing claims against their employers, advising on settlement agreements that they've received, support with general employment issues, and advice on post-termination restrictions. So we do act for both. Okay, so today I really wanted to try to give you all something useful to take away as business owners growing your own businesses. I was hoping to give you some content today that might be of use to you as opposed to just talking about myself. So I have set out some top tips on that I would urge all businesses to think about to make, because I'm conscious you've worked hard, you've grown your businesses, you've invested your time, your money, your efforts into that. So it's really important to think about protecting that business moving forwards. So the first top tip I have is when you decide to engage somebody, firstly, make sure that you've correctly identified their employment status. So we have three types of employment status. We have employee, we have self-employed, and we have a worker. So the first thing I always say to clients, particularly if they're a new business and they're thinking, oh, I'm kind of ready to, I need some resource, I'm going to take somebody on, is okay, let's look at making sure we identify the best way of doing that for your business and make sure that we get their status right from the start. It's really critical because flowing from that, you're getting the right documents in place, because ultimately and you're managing that working relationship accordingly. So why is that so important? Well, if it's ever challenged, the law and HMRC will actually look at what's happening in reality. So you may have a common example is a client comes to me and says, I've got this person, they've been working for me for 3 years on it. They're self-employed, pay their own tax. They've got a self-employed contract, they're self-employed. I might look at it and it might be that they are paying their own tax and their document might say self-employed, but actually they are being managed, they might have a target, they're quite integrated into the business. All those sorts of things might actually lead to me saying, oh, I'm not sure they are self-employed. They're actually an employee because of how you're managing that working relationship. So if that individual later decides to bring a claim, and our first position is when you can't, because you're not an employee, you don't have the right to bring that claim. If a tribunal looked at it and decided that that employee was actually employed by virtue of what was happening on the ground and how that working relationship was working in practice, then the result is that they could bring claims in the tribunal, and that could include claims for backdated holiday pay against you, backdated pension contributions, and there's also HMRC implications there too in terms of backdated tax and NI. So there can be really costly mistakes to make. So I always urge right from the outset, make sure you know what that person is, take advice, get the right documents in place, manage that working relationship accordingly, and it reduces your risk there. My next top tip is to make sure you're protecting your confidential information. And again, this is a really important one. So the minute you engage somebody's services, be them self-employed, employed workers, they have potentially got access to critical information that makes your business what it is, that makes your business a success. You're letting people into your life, you're letting people into your business, you're giving them access to really seriously confidential stuff. So it's really important that you're protecting that early doors. So I'm just going to touch on touch on what types of information can be protected and what we can do, what legal tools we can use to protect that. So slide 6 just has some examples of the types of confidential information that these people that you're letting into your business life might have access to. I'll let you I won't read those out, just take a moment to have a look at that. It's fairly self-explanatory, obvious stuff. But that's the kind of stuff that is really important to you and you're letting them see, you're letting them have access to. Okay, so what can we do? Well, the law gives different protections depending on the type of information that it's classed as. So some of the information is inherently protected at law, it just is. And trade at the top of the list there is trade secrets. And the definition of what makes a trade secret is on the slide. It's a specific form of confidential information that's commercially valuable and treated as a competitive advantage. So that's the definition of a trade secret. So it's quite a high bar. We've then got wider confidential information that you might have in your business that doesn't meet that definition of a trade secret, but it is really important to you and super confidential. Sometimes there's a crossover and things can be both. So, oh, my battery's running low now. My goodness, bear with me. I think I'm not plugged in. Really not great with tech most of the time. Okay. So the next slide. The next slide then is touching on what the law automatically protects. So during employment, so when that person is employed by you, the common law position is that your trade secrets and your wider confidential information are both protected. So whether you've got a contract saying all that in place or not, the base position is the common law will protect that information during employment. The risk creeps in after employment, because after employment, unless you've got express written protections in place, that the law only protects your trade secrets. And as we can see from the definition on the previous slide, what makes a trade secret is pretty hard to achieve. It is a high bar. So unless you've got specific written contractual protections in place, the law will only protect your trade secrets post-employment. And that brings with it a level of risk. So it's critical in order to protect your confidential information to have those written provisions in place. Okay, so some examples of what we would do to help you to make sure that you're protected. So when I'm drafting an employment contract for a client, I'm always putting in place very carefully scripted and very bespoke confidentiality obligations clauses. So what that means is I'm listing in that contract what you as a business consider to be your confidential information. So let's list it really clear. So we're saying to that employee, you're coming to work for us. This is our confidential information. This is what is really confidential to us, and we can be as specific as we can. It's really important. And then going on to say, you have a duty, employee, to keep this information confidential. It's ours, and you don't disclose it, you don't copy it, you don't share it, you don't use it for your own nefarious purposes. It's ours, and you keep it confidential. And making really clear in the clauses the consequences if they breach that. So we will come down hard on you, we will take action against you. And I'm making sure that that really well drafted and specific confidentiality clauses is really well incorporated into your employment contracts. The employee's signing it, so that it's going to be very difficult for them later to say, oh, I did take all that, but I didn't know it was confidential, because actually we're saying, well, here you are at clause 11, signing to say that you accept all of that. So that's a really important thing for you to do, because ultimately, once they leave, if you haven't done that, a lot of that information might not be protected, and they could go away, set up and compete with you and use all the stuff that you've set up and all those links that you've worked really hard to make to set up a competing business. Okay, there are some other useful tools on this slide to protect your confidential information. We did not long ago, about 3 years ago, we had a case where an employee had downloaded a massive amount of really sensitive company information she'd emailed it to herself and to her boyfriend, who was an ex-employee, as they had this lovely plan to set up and compete with our clients. And this included, it was customer lists, it was pricing strategies. She'd even downloaded their staff contracts and handbooks to use those as templates for recruiting her own employees. We successfully helped our client to secure an injunction. We stopped her in her tracks, but the GDPR, so the General Data Protection Regulation, was really useful for us there as well, because she got reported to the ICO, so the Independent Commissioner's Office, who also prosecuted her. So that was a really useful tool we could rely on again. As well. There are other things, data protection rights, that I won't go into that in detail. That's a subject all on its own, and I don't have time today. But there are other ways of sort of creatively protecting, and more practical things as well. So internal things you can do, which I've listed at the bottom. You can put systems in place. There's great software that you can get that will identify if an employee's downloading weird amounts of stuff. Restrict access, restrict who's sharing, who you're sharing the information with. So there's lots of practical tips we can advise clients on as well, to complement having really well drafted contracts covering that very thing. Another thing we can do to protect or help you protect your confidential information is to make sure that you've got really robust, enforceable, restrictive covenants in your contracts. Many of you will have had these in your employed lives. You may have them in place for people that you're currently engaging. I think that some people come to us and automatically assume that they've got these restrictions for 3 years, they can't compete for 3 years, and they assume that those are binding. On the flip side, we get lots of people saying, well, there's no point, they're not worth the paper they're written on. We hear that a lot. It's not true. I mean, it's true that the courts don't like these things because prima facie they're restraints of trade. So the prima facie position is they're trying to stop people making a living, and everyone has a right to make a living and earn. So they can, if they're not drafted well, they can fall away and be absolutely of no use. But if they are drafted well, they have a really good chance of being relied upon. So again, I could talk for hours on these, but essentially you've got to show you've got a legitimate business interest to protect. So it's not just about protecting everything that's, this, it's mine, it's mine. It's about saying, okay, what is it you critically want to protect? And usually that is your confidential information. It's your customers, it's your clients, it's your suppliers, it's your referrers, it's things like that. So firstly, we identify that, and then we make sure that we're not going so when we're drafting these things, we're not going any further than we need to in order to protect that. So don't make them unnecessarily long. Don't try to restrict everybody, only do it where there's an identified risk. Take into account things like the seniority of your employee. So I don't know, a commercial director, for example, is probably going to be more risky to you than a middle manager because they've had access to much higher level stuff. So these clauses, if bespoke to the individual and to the type of information they've had access to, they can be really, really effective. But the drafting is critical to maximise your chances. I advise and draft quite a lot of post-termination restrictions. It's quite an interest of mine. So, by all means, if anyone's worried about this, do reach out, because if they're drafted well, they can be so effective to be relied upon, but they can also be a massive deterrent to your employees when they've got a really good set of restrictions in the contract. It might make them think twice. And people do usually think, well, I've got those. I'm not, I won't chance them. I'll adhere to them. And as a team, we've had our post-termination restrictions contested in the courts, and they've stood up to court scrutiny as well. So we do have quite a lot of experience in these. Just a quick note at the end is, if you do suspect someone you are engaging is up to no good and you think they might be starting to compete or they're starting to act a bit weirdly, and you suspect that sort of activity, then watch your own conduct. If you do have post-termination restrictions in place and they're brilliant and they're really enforceable and they're good, if you act in a manner towards that individual that the courts might say has breached your employment relationship with them, then that might mean that the court would find that those restrictions are not binding on that employee. So your conduct as an employer can hang yourself, basically, because you can end up doing something that then gives the employee the right to say, I'm released from my restrictions, which is hugely frustrating when you've gone to the effort of having those restrictions drafted up in the first place. So again, just watch your own conduct and take advice if you think somebody's starting to act in a suspicious way. Okay. And the type of restrictions we might draft up for you. So we can draft restrictions that say a non-dealing, so you can't deal with our customers, our suppliers, our referrers for a defined period of time. And again, the length of that period of time very much depends on that person. So not a blanket for everybody, because if you want the best chance of enforceability, you need to be bespoke. Non-solicitation, again, so don't solicit our clients, our customers, with a view to selling to them or dealing with them. Non-poaching, that's a good one. Don't take our key staff, because it prevents the situation where one director leaves, takes another director with him, and off they go together and set up and compete. Non-compete clauses, these are the ones that the courts particularly don't like. And usually you can get away with having minimal non-compete clauses if you have the three ones above drafted well, because usually having the dealing, the solicitation and the poaching drafted well can prevent the need for non-compete to a point. But again, I do put them in contracts. We're careful with those because they're the ones that the courts massively don't like. And garden leave is a brilliant tool. A garden leave clause in your contract is critical because it enables you, if that individual hands the notice in and you don't want them to spend the notice period secretly downloading your stuff or secretly making notes of customers and telling people where they're going, you can require them to stay at home on their notice period, put them out, get them out of circulation for the entirety of the notice period, which again gives a nice gap for you to then nurture relationships with their clients and customers with somebody else in the team, which then means that by the time that person's finished the notice period, your clients and customers have established a relationship with their successor or with someone else in the firm, which again massively helps in reducing the risk of that client then going away.
But Georgina, you've only got a couple of minutes left.
I'm on the last rattled through it an hour. Some additional contractual protections in there as well. I won't go through in detail, but there's things you can do, put in your contracts to delivery up provisions, things to make sure they delete information when they leave or on their last day, obligations that they have to share the restrictions with prospective employers, and clawback provisions to tell you if you don't do things, we'll get them and we'll we can deduct from you. And finally, actions you can take. Again, I won't go through those in detail, but we can help get undertakings from exiting employees to say they won't do these things. We can help with injunction proceedings. We can help with claims for damages if that employee leaving and competing has caused you financial loss, and so on and so forth. So that's a really quick. I hope there was something of use for you there. It was a lot of content very quickly. I'm happy to share my slides if that helps, but just a bit about us again at the end. Thank you.
Any questions for Georgina? Take yourself off mute if you've got any.
Georgina, that was very interesting. Thank you very much indeed for that.
Thank you, Rob.
So one thing I was thinking of, increasingly more and more people are using a team offshore. And certainly in the way that Northern Tonic's model works, we actually are contracted to a UK-based company who then has a subsidiary, as it happens, in India, and then they employ people in India. Now, I'm labouring under the assumption that given the remoteness of the relationship, I am clearly not the employer. But in practice, I am, because I control their workload, I control the customers that they work on, I control how they do things. They use the Northern Tonic process. And I just wondered if you'd come across any scenarios where anyone who is an offshore team member is actually able to gain the benefit of employment rights in the UK.
So who are they working for then, Rob? So you're Northern Tonic based.
Yeah, they work for Northern Tonic. Yeah, they work for Northern Tonic.
On a contracted basis, though?
So the contract I have is with a company, whatever limited. And that's who I pay my money to. And
then so usually you I mean, it's difficult to answer that.
Yeah, I'm not really asking for a legal opinion. It's more the generality. I just wondered if you'd ever heard of any scenarios where people have got themselves mixed up in some kind of employment tribunal.
And then start to say,
even though it's perceived completely offshore and remote.
And it's not dissimilar to situations. We've got one particularly big client that's an agency, and they're engaging their agency workers, and then we're the end user. So we get quite a lot of claims from these workers claiming against our client when actually the jurisdiction, then actually the right person to claim would be that the agency that's in the middle. So it's that sort of situation. But yeah, absolutely. And I think in that situation, they're providing a contracted service to you. So I wouldn't be overly concerned necessarily about employment status issues. But the problem is, all it takes is one person to bring a claim and have a go, and then the courts will always look at the specifics of that particular situation. But I think because you're contracted with that organisation, then that's engaging those people to provide a contracted service to you. But yeah, I mean, there are all sorts of and particularly with foreign employment, employees and workers and individuals in different jurisdictions, it can loads of complicated issues can crop up, Rob. It's not unusual to find the courts are often looking at that sort of thing.
Yeah, I mean, I think it's going to become an increasing issue, isn't it?
Just one point on that.
Oh, well, it is. Yeah.
Sorry, Rob, just one point on that. It might be worth looking at the managed service company rules as well. Just from a tax, I don't know anything about legal, but just from a tax perspective, it might be
tax perspective as well. Yeah.
Could I just ask? I mean, I've seen the fading away, I suppose, if that's the right term, on non-compete rules over the last 30, 40 years. How strong are they now? Can they get away with more than sort of 3 months, or is that sort of
Yeah,
rule?
absolutely, Max. I mean, with some, if you're looking at restricting really senior members of the staff, you can potentially go up to 12 months. I mean, the typical base position, I said, with your non-competes, lower 3, 6 months max, really for your non-competes, but for your non-solicits, your non-poaching, all of those non-dealing, you absolutely can get away with longer than 3 months. I mean, for the most part, most of those sorts of restrictions, for you're looking at a minimum of around 6 months. But again, it's easy, it's very much dependent on what that person's doing, what they're accessing, how much of a risk they are, because the shorter you make them, the more enforceable. But obviously, you need to really look at that working relationship to understand how long do I really need to restrict this person for before they cease to be a risk. And what it ultimately comes down to often is how long I need to take them out of circulation to enable their successor to have a good solid rapport with that customer or that client, so that
Yeah.
then that person isn't as minded to leave and follow that employee in 6 months' time. But there's still, yeah, we do draft a lot of post-termination restrictions. But you're right, Max, the non-compete ones are the ones that are less liked and often less enforceable because they're much more general. And ultimately, people have the right to make a living, people have the right to compete. It's just they haven't got the right to take your information and nick your customers and nick your clients.
Yeah. No, but just looking at Colin Townsley's comment there, I think that whole be aware of what is accessible and what is shared amongst teams, whether they're associates, as in Colin's case,
And
consultants.
I think that's the
Very
most
valid
important thing is
reminder.
get that nailed on, get all your confidential information protected and get all your protections in place. We have so many clients and you just think, oh, if you'd just done this, you wouldn't be in this situation, or at least we'd have a cause of action. Because what the common law gives you post-employment is very limited.
Very
And it
good.
can be a nightmare if you've grown a great business and suddenly somebody's nicked it all and they're doing it, and do possibly sometimes doing,
Yeah.
doing it more successfully and it's on the back of your hard work.
And we thought we were worried about Russians, there you go.
Exactly. It's all closer to home.
Brilliant. Excellent.